Actually, I've been asked to speak on the question of four labor codes, which are recently passed by the central government. And all these things were there. There were 29 labor laws. And instead of the labor laws, the government of India has bundled out everything into four labor codes. And so many laws are combined into one or the other code. Code on minimum wages, code on social security, code on industrial relations, and code on many other things are there, health, working condition, safety. This way, four labor codes are brought. And actually, three agencies are involved in this, the stakeholders. One is the government, another is the employees, and then the employees. And the codes, what they are up to. And all the 29 labor codes, most of them were in protection of the working class, protection of the rights of the workers. And now the codes, they have diminished all the obligations of the employers. They have removed, they have given total immunity for the employers for hire and fire and remove anybody at will, and even to fix wages. For everything, there is a total freedom given to the employers. On the other hand, employees, whatever protection they enjoyed up to now, whether with regard to retrenchment or regarding layoff or regarding lockout, all these things, there was government permission was required. And this was under the Industrial Relations Code now. Now earlier, any factory which is having employees more than 100 had to seek a governmental permission, whether for retrenchment or for lockout or layoff. Now that has been increased, meaning more than 300. Actually, by that, about 80% of the working class, they are freed of all immunity. They had immunity from this labor law. There was protection. Now that protection is gone. Only few industries who are employing more than 300 workers, only they have to seek permission now. Up to 300 employees, they did not seek permission, meaning there is hire and fire. And even fixed term employment is there. About that also. Then what is the question of minimum wages? They are going to fix the minimum wages. That means there are no more going to be any permanency of job. They will bring fixed term employment, or they will go for contractualization of employment. And actually, up to now, there was one very important law which was brought in 1970. That is, Contract Labour Regulation Act was brought in the year 1970. And wherever there is a job of a permanent, a perennial nature of job, it has to be, permanent employees have to be appointed. And by chance, if contract employee is appointed or casual employee is appointed, if you go to the court and if you are able to prove it is a job of perennial nature, for years together job is there, then the court had to strike down the contract and they had to make them permanent employee not only, all the back wages they were supposed to get. There are so many employees who benefited from this act. Now this act is gone. Now actually, ultimately, no permanency of job is there. All jobs are made temporary and casual. That means there is no job security, no security of money. Nothing is there for the employees, and everything is in the benefit of the employers. And what they have made? Earlier from the government agency, there is labor conciliation, there are inspectors, and the inspectors used to go on surprise check. And if they find many of the provisions of the Factory Act or ID Act, if anything is violated, they could always take action. And action against employers means such penalty was there, even they could be imprisoned. So employers were in fear. They were not supposed to violate any provision of the law. Even they could be imprisoned. Such cases were there. And now they are freed of all this fear. No question of imprisonment. Employers at best they can be penalized with money. Penalty is there. Amount is to be paid. If they paid amount is over. And what about inspection? Inspection, if they go, they have to go for inspection after serving notice. That means there is not going to be any surprise inspection. No inspector, they are called inspectors and facilitators. They are no more just inspectors. Even serving notice they have to go for inspection. That means the role of the government in checking the violations, gross violations by the employers, even that is taken away. Again, there was a hard-won right of strike by the working people, and everybody knows that an employee is defenseless against an employer, very powerful employer, who is moneyed. That's why after long struggles, the working class won the right to strike and collective bargaining. That's why they can give shape to trade union and go for strike. And up to now the law was, anytime the working class, they can go on strike, serving a notice. But only for public utility services, 14 days notice was there. And now, they have made it according to the code on this industrial relation. They have made it that the working class, if they want to go on strike, they have to go notice of 14 days up to 60 days. Meaning, that is the period they have made to serve the notice. Anytime within 16 days they can go. But the point is, what a surprise thing used to be there, strike. That was the weapon of the working class. Anytime they can go on strike because they are powerless in front of the moneyed class. Now that surprise strike is gone. They cannot go on strike. Now the employers will be prepared with alternatives. They will see that the strike is becoming a failure. So this is another very damaging thing, attack on the working class. In totality, all the labor codes are brought in favor of the owners because it was the pressure of the employers all through that for their doing ease of business. For ease of business, all these labor laws are obstacle. So because of the pressure of the employers, the owners, the government has yielded and brought these labor codes by withdrawing all the 29 labor laws. In one word, it is a big attack, very big, deadly attack on the working class. They are totally losing all protection, whatever they enjoyed up to now. It is up to the trade unions, 10 central trade unions, other than BMS, all the central trade unions, they are together, they have raised voice, and it requires not only raising voice, not sufficient. What we require is mighty movement, united movement of the entire working class of India. Only then we can pressurize the government and see that the labor codes are withdrawn and the 29 labor laws are brought back. This is the appeal of All India United Trade Union Center.